Hey guys, welcome back to the Law Read Slowly. So, we are continuing our discussion on the Code of Civil Procedure 1908. In the last session, we recapped our discussion. We added a lot of new points into the discussion about plaint, into the discussion about verification and affidavit, in the discussion about commissions. We have also done with the writing about the discussion on commissions. I made you write the discussion that we have done. I also made you write a couple of quotations from the Salem Advocates case. Today, we are going to begin with the discussion and dictation mostly of the topic of plaint. There are a couple of points that I am thinking I should tell you because they're not something that will be indispensable to your discussion, but something that will add on a little more flavor to the understanding of concepts. I will keep on adding them as I dictate them to you, so then you can write them, and as you read them it will become clearer to you. So let's start writing, and let's begin by writing on plaint first, and then we will proceed to write about affidavit and verification. Sounds good? So please begin writing. If you want, you can give the title as plaint. Let me also pull up some cases. Start writing in the meantime. When we speak of a plaint, when we speak of a plaint, we are referring to the document. We are referring to the document in which the plaintiff sets out, in which the plaintiff sets out his pleadings, his pleadings before the court, full stop, full stop. It is the formal statement, it is the formal statement of the plaintiff's case. It is the formal statement of the plaintiff's case, full stop. Through it, comma, the plaintiff gives, the plaintiff shape to his, gives shape to his grievance, 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 in a form, in a form that the court, that the court can examine, can examine and adjudicate upon, and adjudicate upon. Full stop. Plaint has been, plaint has been dealt with, dealt with by order 6, order 6, read with order 7, read with order 7 of CPC, of CPC. Full stop, full stop. Plaint initiates a suit, plaint initiates a suit, hyphen, section 26 of CPC, section 26 of CPC, read with order 4 of CPC, order 4 of CPC, full stop. Without fulfilling the, without fulfilling the guidelines, guidelines and rules laid down, laid down in orders 6 and 7, in orders 6 and 7, a plaint, a plaint is not said to be, is not said to be properly, properly filed, filed, and hence, and hence a suit is not said to be, a suit is not said to be properly instituted, properly instituted. Full stop, full stop. Now here, if you think about it, this logic, this reading is itself enough justification for the court to declare that without an affidavit your plaint is not a plaint. In fact, the court has the freedom to declare any of these reasons: signing, verification, affidavit, writing it wrongly, to all be the reasons to not consider your plaint to be proper at all, or your suit to not be filed at all. But through judgments and jurisprudential interpretation, the court has held, for example, your verification and signature to be curable irregularities. Therefore, the consequence of their non-inclusion will not lead to considering that your suit has not been filed at all, or that your plaint has not been filed at all. But for affidavit, they've held that if you don't attach your affidavit, then your plaint is a non-plaint. And that is the logic. The logic is order 4, which says that you have to comply with order 6 and order 7. If you're not complying with it, then your plaint is not proper. It will not be said to have been instituted. So the court can easily use that logic and say that because affidavit is part of order 6 and order 6 needs to be complied with under order 4 rule 1, and you're not complying with it, so directly there's a clear, you know, a legal justification to lay down the rule that we will not consider your plaint to be a plaint at all. That's why I made you write this one line. Come to next paragraph, next point, whatever. A plaint, therefore, a plaint, therefore, contains the cause of action, contains the cause of action, comma, the matters that are an issue, the matters that are an issue between between the plaintiff and the defendant, between the plaintiff and the defendant. You make out your cause of action, right? Comma, certain certain technical pleadings, technical pleadings. Now think of yourself how better placed you are to understand this loaded word like technical pleadings. Now you know what are technical pleadings. We've taken so many examples. So every day, judge yourself how far we have come from session 1 to session 11, I believe now. How far we have come in the discussion that when you hear certain words which you wouldn't have been able to make head or tail out of, now you can easily move along by just mentioning the word. So technical pleadings, comma, the prayer, the prayer, comma, the verification, comma, the affidavit, comma, list of documents, list of documents, and and vakalatnama, vakalatnama, full stop. Some parts of the plaint, some parts of the plaint explain why the plaintiff has come to court, why the plaintiff has come to court, full stop, full stop. I can end this discussion dictation here, or I can make you write a few more things, or I can just take you into the case laws on verification and affidavit and give you dictation on that. Because what I'm going to dictate to you now are simplified versions of things that we have understood. The way we have understood them, that is what I'll make you write if I make you write now. You might as well write it if you want. Start writing. So I told you that some of them are used to put down the reason for plaintiff coming to court, full stop. Some identify the the exact controversy between the parties that require adjudication, full stop. Some satisfy the procedural requirements, some satisfy the procedural requirements. This is just an elongated version of what we have just discussed. We've discussed that we will write technical pleadings in the plaint. What are these technical pleadings? They're helping you fulfill the procedural requirements. Your limitation is there. You've paid the requisite court fees. You have come to the correct court. What tells you that you have a right to come to the court? Your cause of action. So this is just a little more elaborate version so that it's easier for you to understand. Maybe if tomorrow you come back and you think, oh, I don't know anything about plaint, then read this. Of course, you should be firstly reading the notes which you are supposed to take as we're discussing. But then if you read this in such simplified form, you'll be able to gain back that confidence again. Full stop, full stop. Together these parts cover cover a dispute, cover a dispute and and put it down in a legally intelligible fashion. In a legally intelligible fashion. Full stop. Full stop. Next paragraph. Next paragraph. A reading of section 26. Section 26 reveals that that every suit every suit shall be instituted by by presentation of a plaint presentation of a plaint or in such other manner such other manner as may be prescribed here in brackets you can write petition, comma, application, comma, etc. Close the brackets. Next sentence. This language is significant. This language is significant. I believe this is enough to tell you this, because if you want to write more, I would just make you write that this tells you that your suit does not only begin by filing a plaint, rather there are other legal forms of documents which can be filed to institute a suit. but I've already given you the example to write in that bracket, so we can keep it concise. Put a full stop, put a full stop. One line you can write, which will also come in handy for you to write your answers or stuff if you're ever writing something around this. Full stop. Thus, comma, the law is not tied, the law is not tied to, to one label alone, to one label alone. Full stop, full stop. Different documents, different documents may perform, may perform a similar, a similar procedural function, procedural function in different enactments, in different enactments. What are these enactments? Substantive laws. So election laws, Representation of People's Act, I believe would be, requires you to file an election petition. We've seen a number of other examples. Arbitration and Consolidation Act 1996, application. Insolvency and Bankruptcy Code, application. Clear? Full stop. Now this is all I feel there's a need to make you write about Plaint. The rest is the drafting that we have already done and the provisions I kept telling you right then and there. Now we'll write about verification and affidavit. I hope we are all clear on the discussion that we have done on verification and affidavit. If you have any doubts, any questions, send them to me. You can write to me over the email and then we'll resolve them. Start writing. Now here I'll also start giving you cases. First, write a general introduction. Verification is a part of the plaint where the person verifying the pleading states which assertions are true to his own knowledge, and which assertions are based on information received and believed to be true, here if you want, just underline knowledge and believed and keep it for yourself so it rings a bell in your mind. Full stop. Verification, comma, therefore, comma, is not a mechanical formality, rather it serves an important function, full stop. It requires the party to disclose the basis on which different statements or pleadings, you can write, are being made, full stop.